I will start with your entry point to that question. I know quite a number of men who are interested in their children, and they are actually they fight to provide, they fight to protect, they fight to have custody. So, as much as that is a general statement, the truth of the matter is any person who is responsible as a parent ought to take care of their children, whether they are married to the children's mother or not.
Yeah.
The issue of the acrimony and whatnot, of course you understand, and with such discussions, people are also able to understand, because sometimes the type of the legal system that we have, the court can only intervene if somebody approaches the court. If no one goes to court, as much as we are crying how unfair is that a man is not taking care, a woman is not taking care, there is little the court can do.
Does it always have to be the persons involved, or say my mother could go on my behalf, or somebody else's mother, or the father could go on the behalf, because probably they're looking at the kids and they're thinking, well, these kids are suffering for nothing, why don't we intervene, why don't we step in? Does it always have to be both parties, the parents and...
So with children, it's a bit delicate, because the person who has to go to court, for instance, you're going to court to seek for custody. If you are seeking for custody for a child that is not yours, on what basis are you seeking that custody?
Okay.
If you are seeking for maintenance from a person, on what basis are you seeking maintenance from a person who is not a parent to this child?
Okay. Can the children then perhaps raise an alarm or go to court?
The children do not, because going to court means you're going to sign some papers.
Yeah.
So children themselves, by themselves, they cannot go to
And in
court.
this case, I'm assuming that this child is probably 20 years old.
If they are 20 years. Now, I have recently seen there is an issue of, in essence, a child is considered a person who is below the age of 18 years.
Yeah.
But in some circumstances, a child still needs the parental support, even when they are beyond the age of majority, which is 18 years. Now, the courts will grant parental responsibility past the 18th birthday. So at that instance, either the child can go to court because they have reached the age of 18 years, or the mother or the father can go to court. But in essence, children below the age of 18, they cannot go to court. They don't have the capacity to sign the court papers. Now, what happens? Somebody goes on their behalf. And this is a person who, either the parent or the guardian, or the parent, the guardian, or the applicant who want to be the guardian of this child. Because going to court means there is a prayer you are seeking before the court. If you have no interest for this child, then which prayer will you be seeking? But then it also depends. If you are going to court to seek protection against violence over these children, then Protection Against Domestic Violence Act has the individuals who are allowed to be the applicant, for which reason then they'll be seeking protection orders from the court. That then, the issue of the custody and maintenance, it is a bit strict, but the issue of the protection against the children or for the children against the domestic violence that either can be brought by the mother, the father, or any person related to them, can be brought by any person who seeks to have the child protected. Yes.
Well, just how many of the people, or of, perhaps looking at both sexes, who are the ones that actually seek, to get guidance more? Because then you'd probably have men coming on board, asking some of these questions. Or is the women that are concerned so much more, and especially when it comes to the factor of making sure that the kids are well, because then it requires for a lot of explaining, and not just one time explaining, but you have to walk with them through this journey for the entire times of your life. But I'm told we have to take a quick short break.